This is Syndication Attorney Field Notes. I'm Tilden Moschetti, a syndication attorney, and today's field note is about Form D versus a PPM in a Regulation D private placement. Here's the scenario. A sponsor said to me last month, "We don't need a PPM, we already filed our Form D," and I understand why that feels right. Both are documents. Both have something to do with the SEC, so they get grouped together in one bucket in the sponsor's head. But those two things do completely different jobs. So let me give you the direct answer first. No. Filing a Form D does not replace a PPM. They serve different people at different times for different reasons. Here's the clean way to hold it in your head. A PPM is pre-sale investor disclosure. Form D is post-sale regulator notice. One tells your investors what they're getting into before they wire money. The other tells the SEC that an exempt offering happened after the first sale. Let me slow down on why smart sponsors mix these up. When you're raising capital for the first time, everything feels like the legal stuff. The PPM, the Form D, the subscription agreement, the operating agreement. It all lands in one pile that feels like friction. And when it's all in one pile, it's easy to think that doing one of them covers the others. So a sponsor files a Form D, sees it go through, and thinks, good, the legal side is handled. But the Form D is a short notice. It has your name, your address, the exemption you're relying on, and roughly how much you're raising. That's it. No risk factors, no conflict of interest disclosures, no deal terms. Nothing that tells an investor what could go wrong. Think of it this way. A PPM is like the blueprints for a building. The Form D is like the notice you file with the city after the building already exists. One defines how the thing is built, like the other just says a thing was built here. Now let me separate the two, because once you split them by audience and timing, you can't confuse them again. Start with who reads each one. The PPM goes to your investors and their lawyers. It's a private document. You hand it directly to the people considering your deal. The Form D goes to regulators. It's public. It sits on the SEC's EDGAR system where anyone can look at it. Next, timing. The PPM comes before anyone commits capital. That's the whole point. Your investors are supposed to read it and decide based on what's inside. It can't protect you after the fact. The Form D comes after. Generally, you file it within 15 calendar days after the first sale of securities in the offering. And here's a quiet trap in that 15-day rule. Figuring out the exact date of that first sale is a fact question. Is it when the subscription agreement gets signed? When the money clears? It depends on how your deal is structured. So that's a date you work out with counsel, not a date you eyeball between meetings. Now, function. The PPM is your disclosure record. It lays out the terms, the risks, and the conflicts. The risk factors section does the heavy lifting there because it's the part that shows your investor was told what could go wrong. The Form D has no function like that. It's a receipt. It's an administrative notice that an exempt securities offering occurred. So let me put a picture to this. A family office is doing due diligence on your deal. Their team asks, "Can we see the PPM?" And the sponsor answers, "We don't have one. We already filed our Form D." To a sophisticated allocator, that answer says something. It says this sponsor may not understand the difference between disclosing to investors and notifying regulators. And if the deal later underperforms, that Form D shows nothing about whether the investor was ever warned about the specific risk that caused the loss. Let me hit a few things not to assume because these come up constantly. Don't assume the SEC approved your offering because you filed a Form D. There is no approval. Nobody reads it and mails you back a stamp. It's a one-way notice. Don't assume that raising only from accredited investors turns off your disclosure duties. Regulation D exempts your offering from registration. It does not exempt you from anti-fraud law. That anti-fraud standard, sometimes called Rule 10b-5, applies to every securities offering, no matter which exemption you use. It's about not leaving out material facts an investor needs to decide. And don't assume that because a particular exemption doesn't spell out a required disclosure format, disclosure is optional. No format mandate is not the same as no need to disclose. The PPM is how you build and keep that disclosure record. So here's the field note. In a Regulation D private placement, the PPM belongs before your investor commits. Form D belongs after the first sale. One is a private disclosure to the people funding your deal. The other is a public notice to the regulators. The pitch deck sells the deal. The PPM documents the risks. The Form D closes the administrative loop. Keep those jobs separate. And don't let a public notice pretend to be a disclosure. Or the short version, a notice is not disclosure and a receipt is not a shield. The longer written version is in the show notes. That's today's field note. I'm Tilden Moschetti.